Welcome, everyone, and thank you for joining us today. My name is Kristen Calvi, and I'm the publisher of Metropolitan Corporate Counsel, a law business media publication. Today, we present the final installment of our four-part series, our four-part director series, Essential Litigation Webinars. In today's presentation, the Defend Trade Secrets Act, a big law partner and forensic technologist's perspectives. We've invited Mr. Milligan, a partner in litigation and labor and employment departments of Seyfarth Shaw, as well as co-chair of the firm's Trade Secrets, Computer Fraud, and Non-Competes Practice Group, and Jim Vaughn, a certified forensic computer examiner and managing director of iDiscovery Solutions, to discuss what the passage of the DTSA means for your company. Before I turn the presentation over to Jim, who will be moderating today's event, I'd like to pass along a few tips to help you make the most of your experience today. You'll notice that there are widget icons at the bottom of your screen. I'd like to draw your attention to just a few of them. First, the TV screen icon is for the presentation itself. If you were to close the slide view, just click on that and it will reappear. Also, to make the slide bigger on your screen, just click on the larger square on the right top corner of the slide screen. You can move and change the size of all the boxes open on your screen. Next, the Q&A icon is where you can type your questions during the presentation. We encourage you to ask questions during this presentation. We will do our best to address them during the live event or at the end during the Q&A sessions. But if your specific questions are not addressed during the webinar today, the appropriate person will be sure to reach out to you individually. Also, if you are having any technical issues during the webinar, feel free to type your concern and someone will reply to you. Finally, as a reminder, this presentation is being recorded and will be made available to all registrants. Thank you for joining us today, and now I'd like to turn the mic over to Jim Vaughn, who will be leading the presentation.
Good morning. This is Jim Vaughn. I'm here with Robert Milligan today. And I am a managing director at iDiscovery Solutions. I have a prior law enforcement background. I did about 16 years in law enforcement, and I've been in the private sector since then. I'm a practicing testifying expert, certified forensic examiner, and that's how I make my living. Robert?
Yes, my name is Robert Milligan. I'm a partner at the Los Angeles office of Seyfarth Shaw. I'm the co-chair of our national trade secret non-compete computer fraud group. We're very excited that you've joined us here today. We want to get down to what you need to know about the Defend Trade Secrets Act.
So what we're going to cover today is how to best identify and protect your trade secrets. Robert will speak to that. Also, what employers need to know about the Defend Trade Secret Act. Robert will talk a little bit about some restrictive covenants, some recent changes, and I'll discuss today how to catch a trade secret thief, response to potential trade secret theft, and then Robert's going to talk about the courts and suing under Defend Trade Secret Acts versus certain state law or both.
Yeah, so the Defend Trade Secrets Act went into effect in 2016. We really have seen an upsurge in the amount of trade secret cases being brought in federal court, and it's really quite significant because it was a real game changer in the sense that federal court was often off limits to trade secret owners unless they had a basis to be in federal court under diversity. And now with the passage of the Defend Trade Secrets Act, you have original jurisdiction in federal court. So if you're a trade secret owner and your trade secrets have been misappropriated, you now have the option to go into state or federal court. It's significant because, as you'll see on the screen, in the grand scale of things, trade secrets in the world of IP were often looked at as sort of the ugly stepchild. But now with the federal property right under the Defend Trade Secrets Act, you're seeing more and more companies focusing in on trade secrets as a way to separate themselves from competitors and really add value to their company. There's been a number of significant trade secret cases in the news recently, the ZeniMax case, the Waymo case, and the Epic Systems case, dealing with really high-end cutting-edge technology, obviously with the ZeniMax case, virtual reality, with the Waymo case, self-driving car technology, and then with the Epic Systems case, medical software. And in that particular case, there was a very large award in the millions of dollars in favor of the trade secret, the plaintiff there. And so what we're seeing now is more and more companies focusing on how to first identify whether they have trade secrets and then see if they could do a better job of protecting those trade secrets so that they can get the most value out of those particular assets. And just when a company is doing an assessment of, well, do we have trade secrets? Because oftentimes companies are very reactive. A high-level executive or a joint venture partner has allegedly done something wrong, and then they want to explore their options. And then they start doing an assessment of, well, did they take anything? Did they use anything? But what I would tell you is that the companies that do this correctly are much more proactive and understand what type of assets they have and make sure that they have safeguards in place on those particular assets. So the building block is really to understand, well, what is a trade secret when you're doing that identification process? Often, to establish you have a trade secret, it's obviously information. It can't be generally known to others. It must be actually economically valuable, actual or potential. And then the key thing is you could have all three of those elements of a trade secret, but if the company doesn't have reasonable efforts in place to maintain the secrecy, then your trade secret will not exist. And so when the Defend Trade Secrets Act was passed and signed by President Obama in 2016, it was really a watershed moment for trade secret owners. Prior to that time, trade secrets were just protected by under state law, at least from a civil perspective. And so under the definition of a trade secret that's put forth in the Act, it lays out a number of different examples of things that would qualify as trade secret. It uses very general type labels, but you can see how broad and elastic the things that will qualify as a trade secret, plans, formulas, programs, devices, methods, techniques. And, as we indicated, you could have all these different types of information, but the owner has to make sure that there's reasonable measures in place to keep such information secret. So you could have the top secret formula that generates tremendous market value for your company, but if that particular secret was shared with third parties without non-disclosure agreements, if it was shared on the internet, if it was provided to employees without any non-disclosure agreements, those are all ways that you undermine and erode the protections of what should be really a genuine trade secret. And so when a company goes about doing an assessment, there really needs to be somebody at the company that has ownership, because if it's spread out and there's really no owners, and somebody that has that responsibility is wearing way too many hats, that's where we find companies don't do a very good job of protecting their trade secrets. And so when you go about identifying the trade secrets, you need to have somebody within your company who's responsible for that and works with outside counsel and even computer forensic folks to make sure that you're honing in on the type of information that really derives value for your company. Some of the identifying characteristics, it doesn't have to be novel or unique. Unlike a patent or a copyright, no registration is needed. It must not be published. If it's published in a journal, if it's published on an internet or scholarly article, that's going to erode and undermine the protection of it being a trade secret. And one thing that's unique about a trade secret is, sort of unlike a patent, two or more can independently possess the same secret at the same time. So if you came up with a formula that helped a widget perform a particular operation, and a competitor did the same thing, and they independently derived it, and it's essentially the same thing, but they didn't use your technology, that's okay. That's perfectly allowable. And then lastly, when you're identifying trade secrets, it can be made up of things that in totality, it can be made up of information that's public in a certain extent, but when it's all compiled together, that's what makes it a trade secret. Oftentimes that could be somewhat of a customer list, where there's different aspects of the customer list either the contact information, the pricing information, the margins information. There may be aspects like the name of the customer that's publicly available, but there are other aspects of that list as a whole that's not, that makes it a trade secret. And so a company that's trying to do this correctly is going to be reaching out to various business units and really doing an assessment of, well, what is it in our company that could qualify as a trade secret? And you'll look at, on the slide that you have here, some examples of trade secrets. And so you really want to have these meetings and these discussions so that you're not missing out on information that could qualify as a trade secret. Get into a little bit more detail about how a company should best identify and protect protect their trade secrets. Now, when you're identifying the trade secrets, you'll see on the next slide is that this particular test has come from a court decision about factors that courts look at when they determine whether the information as a whole is a trade secret. As we indicated, if it's publicly known, it's likely not going to be qualifying as a trade secret. So if the information is well known outside the company, with competitors and with the public as a whole, likely not going to qualify. So it's this kind of lens that you put into assessing information when you're having a conversation with your business unit as far as, well, is this information trade secret? When you start asking those questions about, well, who do you disseminate it to? How does the company derive value for it? How do you protect it? Who do you share it with? You can see these other factors, some that we've discussed with respect to the value of the trade secret to the company and competitors, the time, effort, and money expended in the development. Certainly if it's something that it's been in a prototype phase that the company's invested a lot of time, energy, and expense to, that's the type of information that may qualify for a trade secret. So that's sort of the low-hanging fruit, particularly if you're a company that relies upon trade secrets. That's where you're going to want to make sure that your non-disclosure agreements are really calling out what your bread and butter is as it relates, to trade secrets. As far as generalized descriptions of that information being provided in your non-disclosure agreements.
And Robert, I'll share with you one of the questions I think came in as timely. And the question is there any implied, quote, implied trade secret that would characterize information as a trade secret if it's simply of a nature that would reasonably be obviously intended to be confidential in the absences of an NDA or other confidentiality agreement?
Those are often the most difficult type cases if you're relying upon implied confidentiality, because the belt and suspenders approach obviously would be if you had some sort of non-disclosure agreement and you had, at a minimum, you had some sort of employee handbook that provided for confidentiality protections and whatnot. So it's not unheard of for there to be a business arrangement where you make the argument that, well, this is what we've been doing for a number of years, and of course nobody in this industry would share the information, but you're somewhat playing with fire to a certain extent. Sure, certain courts have found that the reasonable secrecy measures were present, but on other instances, other courts have found, well, no, if it was really that valuable to you, you should have had some agreements in place. And that's sort of part of the assessment when you're doing a trade secret inventory and an audit, is first to get a handle on the type of information you have, and then once you do the triage of what's the most valuable information, then do an assessment of how you're actually protecting that information. And so if you're sharing highly valuable information in the supply side to create your product, and that supply side partner is somebody that's in a foreign country, and you don't have agreements in place with them that govern the use and disclosure of information, you're basically you're playing with fire. And could you get remedies? Could you get relief? Sure. Could it blow up in your face? It could, that as well. So when we talk about companies getting an assessment of their trade secrets and how they protect it, oftentimes we recommend that they engage in an audit. In this day and age where legal spend is at a premium, and sort of reactionary, where proactive type products are hard to sell. Honestly, companies that are doing their best to identify and protect their trade secret are so far ahead of other companies that are much more reactive and are much more successful in, number one, not letting that information get out so that you have to deal with litigation. But number two, if you do have a rogue employee, you do have a rogue supplier, you're 10 steps ahead because you already know what your information is, you already know what agreements you have in place to protect that information, and you'll do very well in litigation. So oftentimes we have them work with outside counsel and computer forensic examiners in doing the identification and the security assessment of how that information is protected. And you'll see that we do a review of different types of information to make sure that it qualifies, for trade secret protection. We do some assessments of, well, how is it that you configure your network? How is it that you distribute laptops? Are you a BYOD house? Do you allow VPN? All these types of things are the types of the assessments that we use outside forensic examiners, computer examiners, to do that kind of assessment so that we make sure that there's not holes in your protections as it relates to your highly valuable information. We do an assessment of their policies, their non-disclosure agreements, see if there's been any changes in the law, that the agreements need to be updated. And then we look about their procedures for onboarding and offboarding of employees, because that can often be where there's holes in the process and where a departing employee can walk off with highly valuable information if you don't have a good exit interview and offboarding procedure. And then we conclude it with some findings and recommendations so that it's a living document, so that they know where they're at in this slice in time, but they know what's going to come in the future, and whether they need to update their agreements, update their policies, and make sure that they're employing a strategy on an ongoing basis. It's not just a one-time thing, but it's an ongoing thing that the person at the company who's responsible for trade secret protection owns and continually updates. And then, Jim, maybe you want to jump in here as far as taking efforts to maintain secrecy, and from a computer forensic perspective, some of the best practices, and that gets into password protection and whatnot.
Sure. So you kind of mentioned as far as like password protection, things like making sure that you have a certain amount of time you change your password. Say, for example, every 30, 45 days. There's no one-size-fits-all, but if you have reasonable measures in place, or what you believe you can defend as reasonable measures, that's pretty important. Disabling accounts when employees leave. Oftentimes, well, not oftentimes, but sometimes we see where employee departs and the larger company may remember to disable their email account, but they might forget to disable their VPN, or they might forget to disable access to certain databases. So you want to be aware of that. In regards to the BYOD Robert mentioned, I think everybody knows what that means, but in case you don't, it's bring your own device. And there's also COPD, which is corporate-owned, personally enabled device. Those types of configurations, you want to make sure that you have control or an understanding of what happens to your data when an employee departs on that device.
And like one of the leading indicators, there has been a few law review articles on this subject as it relates to trade secret protection. They did an assessment of court decisions as far as when they found trade secret protection and when they found that the trade secret protection was not in place, and therefore they were not willing to issue an injunction or provide relief to the company. And the leading indicator was whether or not the company had a non-disclosure agreement in place with the employee or the joint venture partner or vendor. And so that's going to be the number one step, is make sure you have a top of the line NDA in place with your partners and employees. And then we talked a little bit about having a consistent and strong onboarding and exit interview process, and then also taking a quick look at how you interact with your vendors and what type of information that you provide to your vendors, and what type of agreements you have in place with those vendors, because they can often be a sieve as it relates to the disclosure and dissemination of your information. That's just based upon experience and what you see in the headlines. So with that, we want to shift gears a little bit and go back to the Defend Trade Secrets Act and sort of a nuts and bolts as far as what you need to know about the Defend Trade Secrets Act. So it went in place May of 2016. So if you're a trade secret owner, as of May of 2016, you now have the right to be in federal court to sue if your trade secrets are misappropriated. And you'll see it created a federal civil cause of action. There was already a criminal statute on the books, the Economic Espionage Act, that dealt with the criminal misappropriation of trade secrets. But what this did is it provided a civil remedy in federal court. Some of the unique aspects of the DTSA is that it provides an extraordinary remedy that's not available under a state trade secret claim theory, and that extraordinary remedy is the ex parte seizure. And what that kind of means in a nutshell is that if you can make an appropriate showing and go to the court and make this showing, you essentially can get an injunction whereby, and an order whereby the federal marshal will knock on the door or crash through the door of the alleged defendant misappropriator and seize the alleged misappropriated trade secret and the evidence related thereto. Now, there's quite the showing that needs to be made in order to obtain that extraordinary remedy, but it's quite the remedy that can be provided. Now, also, the typical remedies that you get in your trade secret cases are also available: a temporary restraining order, a preliminary injunction, and obviously a permanent injunction, and then actual damages, unjust enrichment relief is also available. And what's interesting about the Defend Trade Secrets Act is, unlike patent law, this doesn't preempt any state law claims. And so you can maintain both a federal claim and a state claim for trade secret misappropriation. Now, there's a little bit of dispute in the law right now, and it's only been on the books for a year now, but there's a dispute with respect to can you pursue a inevitable disclosure type theory under a federal claim for violation of the DTSA. And I think that the clear intent of what Congress was doing here was that they were not going to allow an inevitable disclosure type theory, but at least some cases to date have allowed an inevitable disclosure type theory of an injunction to be allowed. And what that means, for those that are not familiar with that vernacular, is that it's an injunction whereby there's a showing that an employee is in such a high-level position and went and joined a direct competitor and is going to be doing the same types of things that they were doing for the former employer, that they will inevitably disclose those trade secrets in performing their jobs for the new employer. And so in certain instances, the court has been willing to enjoin their employment in whole or part in taking such a position. But like I said, I think the legislative history under the DTSA indicates that that's not what they were intending. Certainly that relief can be available in certain state jurisdictions. Another unique aspect of the DTSA is that it requires employers to provide notice to employees of these employees' whistleblower rights. And essentially that means that if they suspect violations of the law, that they have a right to disclose those potential violations of the law to law enforcement as well as to their attorney. Now, this is a requirement that in rolling out a non-disclosure agreement to an employee, that you need to make the employee aware that they have a right to disclose the trade secret in those instances where there's possible wrongdoing to their attorney or to law enforcement. This was a unique add-on to the law that there wasn't a lot of debate. It was kind of at the end of the cycle as far as when they were getting ready to pass this law. And I think to a certain extent it emanated out of what was going on in Europe at the time. Europe, the EU, was in the process of passing a trade secret directive, and they wanted to make sure that there were clear protections for the media and that there was also clear protections for whistleblowers so that companies couldn't keep them from disclosing possible violations of the law to regulators and their attorneys. Now, when we look at the actual whistleblower employer requirements, that's on the slide right in front of you. And you can do it in your non-disclosure agreement. You could also cross-reference your employee policy on whistleblowing activities. And what I mean by that is that oftentimes employers in their employee handbooks will have a provision that deals with if you're a potential whistleblower, what process the company wants you to follow. And so long as that policy is consistent with the requirements under the Defend Trade Secrets Act, you can also just cross-reference your policy in your non-disclosure agreement. Or your alternative is just to provide a short statement about the employee's rights under the whistleblower section of the DTSA in the non-disclosure agreement itself. What's interesting about this requirement is that I think it was obviously drafted by IP attorneys and legislatures rather than employment attorneys, because they define the term employee who has these whistleblower rights as employees as well as contractors and consultants. And typically, obviously, in the labor and employment world, there's a huge difference between an employee, a contractor, and a consultant. But this requirement applies to both employees, contractors, and consultants. So if you're asking them to sign a non-disclosure agreement, you're going to want to provide them with their whistleblower immunity rights. And so in the next couple of slides, and we'll plow through these in the interest of time, I've provided two different formats that you could use with your non-disclosure agreements. One is more of a belt and suspenders approach that actually tracks the language of the Defend Trade Secrets Act so that there's no ambiguity about whether or not you've complied with the notice requirement. And so you'll find that on the slide in front of you, and then carrying it on to the next two slides. And I think, when you look at slide 18, what's important to point out is that these whistleblowers, they don't have to be right. It's for suspected violation of the law. So, there could be a good faith belief, but it also protects the crazy people who believe that, there's a suspected violation of the law where they're clearly not. That's where employers really have to be careful, because the employee doesn't have to be right. They just have to believe that there's a suspected violation of the law.
And Robert, I'll make one comment on the whistleblower clause. I recently had it's been a little while now, but recently had a case where forensics came into play on a whistleblower claim. The ex-employee was claiming that they were sending themselves sensitive information for purposes of being a whistleblower. But the forensics actually revealed that they had been doing this for well over 11 months, and that really hurt that whistleblower claim.
Yeah, and that's a good point. And I think in the big picture, when you step back, the big thing here is the fact that you now have this federal property right under the DTSA. That's huge. That's significant. It's putting trade secrets at the same level as copyrights, trademarks, and patents, that you have that federal property right. And that's really what companies need to focus on and make sure that they're buttoning up, their strategies as it relates to that. But then you have to think about how this plays out in the practical world in litigation. And if you're a defendant, if I'm representing a defendant in these type of cases, I look at what the information was and why it was taken, and can I try to leverage a defense that I was taking this information because the company was doing something wrong? Because that, as you'll see in our discussion, that's going to be an affirmative defense to a claim for trade secret misappropriation. And it doesn't come up in all cases. It does come up in some cases where the employee believes that the company is doing something wrong, takes a whole bunch of data, and then the company sues for trade secret misappropriation, and they say, wait a second, I took this because they were engaged in all this nefarious conduct and whatnot. So yeah, I think the fact that now you have this codified, this whistleblower immunity right, you're going to see more of these types of disputes, rightly or wrongly, about whether they're a whistleblower or not. You're just going to see more of that, more of those type cases. So we're still in the long form on the slide, so we'll go to the next slide. And that's the conclusion of the long form belt and suspender approach on the whistleblower language that you should be putting in your non-disclosure agreements. Oftentimes I have general counsel saying, I don't want to invite whistleblowers. I want to comply with the law, but I don't want to give good people bad ideas. That being said, if you want a more plain language version of the notice requirement, you could use this language here on slide 20. It's a more plain language version that can be included in your non-disclosure agreement. Now you say, well, what happens if I decide I don't want to include this whistleblower language in my non-disclosure agreement? Well, I think that's going to be developed over the case law, but I can tell you one thing is that if you're a trade secret owner and you wanted to be in federal court and you wanted to sue for trade secret misappropriation and you didn't have the whistleblower language in your non-disclosure agreement, you will not be able to get attorney's fees, and you will not be able to get exemplary damages, punitive damages. And so that's one of the incentives. But I think, and as we go to the next slide, I think there's going to be some more practical consequences if you do not include the whistleblower immunity language. And I think what those practical consequences are is that courts will view your agreement as outdated and as something that's not, top of the line, something that's not in compliance with all applicable laws. And I think in some states that have very broad, unfair competition, unfair business practices type laws on the books, they may point to the federal law as a basis for that a reason why your agreement is not in compliance, and they may view your agreement with a certain lens when they evaluate your non-disclosure provisions, your non-competition, non-solicitation type provisions that may be included in that agreement, and it may jaundice their eye as far as how they want to enforce your agreement or more likely not enforce your agreement. So we're typically recommending that all our clients include the whistleblower immunity type language. And also government regulators may view the fact that you're not expressly calling out these whistleblower immunity provisions or protections in your agreement as a way to crack down on you. And certainly the SEC, the EEOC, they've been looking at opportunities to go after companies that are trying to chill employees from reporting violations of the law, and they may use that as an additional example to say, well, yeah, you're not encouraging these employees to report possible violations of the law. In fact, your agreement's out of date. You're not complying with the law. So that's one thing to be.
And Robert, while we're on the whistleblower topic, one of the questions: would these whistleblower provisions not apply to NDA or confidential agreements with non-employee third parties?
The answer is who is the third parties? Because, like I said, it's not you're supposed to use them with employees, but the statute itself says independent contractors and consultants, right? So if those third parties are independent contractors or consultants, you should be asking them to have the whistleblower immunity language in the agreement. And so when we look at what you should do now is you should update your non-disclosure agreements with employees, contractors, and consultants. You should contain the whistleblower immunity notice or a cross-reference to your whistleblower compliant policy. And then, lastly, before we jump into the next topic, is that I made mention that employees that take data related to their take data related to their whistleblower claim will have an affirmative defense under the DTSA, and we saw that played out in the Unum case in Massachusetts. Now, in this particular case, the employee was suspected of trade secret theft. The employer demanded the return of the documents, and then the employee refused on the grounds that he had taken the documents to give to his attorney and to investigate a violation of the law. The employee filed a motion to dismiss in federal court, and what the court did is denied the motion to dismiss, and but created some law here, and that's why we're talking about this. Is that the court for the first time in construing the DTSA said yes, employees do have an immunity defense. It's an affirmative defense that they have to prove. And at a motion to dismiss, where you have to assume everything in the plaintiff's complaint is true, the record lacks facts to support or reject that affirmative defense. And the court pointed out that it wasn't ascertainable from the complaint whether the defendant turned over all the documents to his attorney and how he used the documents, and if they were all used for the purposes of investigating a potential violation of the law. And so it was premature to dismiss the plaintiff's case on that basis. And in fact, the employer ended up, to a certain extent, winning one of the larger battles in this case, in that the court granted the employer's a motion for a preliminary injunction and required the defendant employee and his counsel to turn over all of the plaintiff's documents to the court and destroy all copies of the plaintiff's documents and not to make any copies. So in that sense, the employer was protected. They also had to provide an accounting as to whether the defendant employee provided those documents to any third parties. And this is significant because what Jim was saying is that we expect that there'll be more type whistleblower, hybrid, trade secret type claims out there. And it's really important to get a computer forensic examiner involved because that's where you're going to, cut the wheat from the chaff as far as, is this a real whistleblower? Because if they were squirreling away these documents for a long period of time and they were using it for competitive purposes, you're going to be able to find that really, quickly as far as what the forensic record reveals. And I think, with this next section, and we're obviously mindful of the time, I think we could go through this next section quite quickly because I do want you guys to get a really good grounding on computer forensics and how they can really help you in a defend trade secret case. But just wanted to give you a brief overview of what's going on with restrictive covenants. Because when you're updating your non-disclosure agreement to take into account the DTSA, you're also going to want to make sure that your agreements have state-of-the-art non-competition, customer non-solicitation, and employee non-solicitation provisions if they're allowed in your particular jurisdiction. Now, there's been some recent changes in 2 states that you should be aware of that are significant, and some other states as well. Now, Nevada changed its non-compete statute, and it's going to expressly allow the court to blue pencil agreements. Now, there had been a Supreme Court decision that prohibited Nevada courts from blue penciling overly broad non-compete agreements. And blue penciling is essentially modifying the agreement. And the blue penciling really is a term of art, and it can mean different things in different states. But in a nutshell, it's basically modifying the agreement to make it more reasonable, more enforceable. And this new statute allows Nevada courts to do that. So it's more pro-employer in that certain respect. But it also puts some limitations on non-solicitation, non-conduct customer clauses in Nevada. And so if you employ those types of restrictions in Nevada, it's really worthwhile to take a look at this new statute because it's providing employees' rights where the customer is the one that reaches out to the employee and asks them to conduct business, which it can be a real landmine if you don't have the right type of agreement in place in that jurisdiction. There was also some changes in the law it's a proposed change in the law in Missouri about whether a covenant not to solicit is reasonable and presumptions in place with respect to customer non-solicitations. We also saw some changes in Connecticut, Rhode Island, and Oregon, as well as Utah related to non-compete law. You can see those changes on the screen. If you want additional details on this, feel free to reach out to Jim or myself or check out our blog at tradesecretslaw.com. I think we've covered most all of these changes in the law on our award-winning trade secret non-compete blog. Lastly, in this category, one thing that you should be aware of is that there was a change in California law as of the beginning of the year, and it applies to agreements that are conditions of employment with employees, and it prohibits employers for specifying a non-California choice of law and a non-California forum for disputes in agreements that are conditions of employment. Now, there are some workarounds, and there are also some exceptions to that, particularly if the employee is represented by counsel, and particularly if the agreement is not a condition of employment. But this is something that's very significant, and it also applies to arbitration forums in the sense that you can't specify a non-California arbitration forum as well. And so this is very significant when you're updating your non-disclosure agreements to make sure you're complying with applicable law as far as choice of law and forum. In the slide in front of you is some, as you're going through this calculus of updating your non-disclosure agreements, it'll provide you with some additional tips to keep in mind in drafting your agreements and revising your agreements. And I think with that, in the interest of time, we should probably turn it over to Jim. And Jim's going to address, using computer forensics to catch a trade secret thief, and then how that plays out in leveraging trade secret claims now in federal court under the DTSA.
Thank you, Robert. And I do want to remind the audience to keep the questions coming. We've had some really good questions. We may not be able to answer all of them within the allotted time, but to the extent there are questions that we believe were not answered during the presentation, we will cover those afterwards, as well as provide you with the slides. Robert, one question before I jump in that came in is inevitable disclosure still good in California?
With respect to inevitable disclosure has not been, good law in California for a number of years. That's the Schlegel versus White case. And so people stepping back from a high-level perspective, there are certain states where inevitable disclosure injunctions are allowed, and California is one of the states where inevitable disclosure injunctions are not allowed. But, let's get real, because the statute itself says you can enjoin actual or threatened misappropriation, and threatened misappropriation of trade secrets can be shown by conduct that as far as part of your exit interview, where you lie in your exit interview, or you take data with you and don't return it. And so the fact that inevitable disclosure is not allowed under California, at least under the Court of Appeal decision, doesn't mean a whole lot, because you can leverage the same types of facts where if you have evidence of deceptive conduct pre-termination and post-termination, and any taking of data to help show the judge that there's a real threat, and that's all it is threat of misappropriation, and they may be able to get appropriate judicial relief, even in California.
Great. Thank you, Robert. So what I'm going to talk about now is primarily how to catch a trade secret thief. I would like to start out by saying that I work on three sides when it comes to this. I work on behalf of plaintiffs, I work on behalf of defendants, and I am often sought out to be forensic neutral. So today's presentation, though, is generally geared towards looking for evidence of the theft of trade secrets. I may interject a few things here and there on the defendant side, meaning that somebody's been accused of taking it, and how do you, refute those types of allegations. But for the most part, you could expect to see more geared towards what people would consider the plaintiff side. So how do they do it? Copy documents. I realize that, wow, that seems kind of odd that would be on there, but it actually still does happen where people will print out documents and actually walk out with them. Now, that's kind of the poor man's way to do it, I would say, not the most efficient way to do it, but it still does happen. Downloading information from computers like external drives, USB devices, thumb drives, I think generally speaking those are all synonymous, and it really and the reason the thumb drive comes into play is because it really is the size of a thumb when you hold up these little devices, and they're pretty big now. I believe they were probably up to about 4 terabytes in size, which is a lot of data. Emailing information is still a popular way to do it, meaning that they'll send emails from corporate email to personal email, or vice versa. They could log into their personal email account from their work computer and attach documents and send it to somebody else other than themselves. Memorizing information, I leave that to the attorney. That's not really a forensic issue. Obtaining information from former employees. I have seen cases where departing employees will call up the HR department, or they'll call up other people and say, hey, would you mind sending me this? It seems innocuous by the person sending them the information, but sometimes it turns out it's not so innocuous. Hacking into computer networks. Now, the term hacking is, I don't know, if you watch CSI and all those fancy shows, that seems to be a nice buzzword, hacking, right? But there may be statutes in a lot of other states. I personally have always, in law enforcement, worked in California, and so there are certain provisions, penal codes that deal with what we call unauthorized access to computer networks. But I do see that bleed into the civil side as well. for people who leave their company and their credentials didn't get disabled and they since go back and log in. Sometimes that gets alleged, and keeping in mind that I'm not an attorney, I only play one on TV, so I'm sharing my experience with you based on just forensic approach. The legal stuff is always argued by the attorneys. Moving forward, Robert mentioned this earlier, and that is just being proactive. Put people on kind of a need-to-know basis based on the sensitivity level of your documents. This also has to do with the level of security access you might give them to certain systems. There are different levels. Let's just use, as an example, let's use your database that might be a contact resource manager or a sales database, where you may give certain people access to just pull certain reports that contain customer information. You may give other people access that would pull more sensitive information, such as margins, things of that nature. Trade secrets on the double encryption comment there, you'll see that. I'm not suggesting that you have to double encrypt everything in your system. What I'm saying, though, is if Robert mentioned earlier about categorizing your documents, some documents may be non-sensitive, other documents may be more sensitive or confidential, and some may outright be what you classify as trade secrets. So what I'm suggesting is also implement that tiered level of security based on the sensitivity of stuff. Circling the wagons to lay the foundation for forensics. So, as I mentioned, the vast majority of trade secret that is accomplished electronically. This is through one thing that I hadn't mentioned quite yet is the use of online cloud storage systems such as Dropbox, SugarSync. Those are just two. I think Dropbox might be real popular. Box.com, you've probably heard of that as well. But when people leave, you want disabled access to all their systems. Now, the one thing I like to always remind clients of is that you will have you could have a high turnover of your IT staff in your bigger companies. In addition to that, you may have certain roles performed by certain IT folks. Like, for example, one IT person may be just in charge of desktop support. Another person may be in charge of your email service. Yet another one may be in charge of your backup systems, etc. So you should never assume that the one person you're talking to is familiar with all the IT systems. So you want to get your lay of the land, and I think that's where your forensic consultant will come in real handy to help navigate the water and do the geek speak translation between IT and HR and the legal team. I'm going to move through the rest of these fairly quickly since we're getting there. And for those of you who have questions that remain unanswered, we will be reaching out to you afterwards, especially for those of you who have asked multiple questions. We thank you for that, number one, and we will reach out. Now, the one caution I really like to tell people is do not play detective. The IT folks are fabulous at doing IT work, but what they will admit to you is that they're not litigation savvy, they're not forensic experts, things of that nature. So the best thing you can do is to quarantine any data sources. Even if you get, as a practicing attorney, if you get something from your opposing counsel, let's just say on a thumb drive as an example, it's always probably best to get an image made of that thumb drive before you insert it to your computer, because you may be interested in what was accessed, when it was accessed, was anything modified, stuff like that. And you want to try to preserve that as best as you can. If that doesn't happen, it doesn't necessarily always kill your case or anything like that. Don't get me wrong there, but just try to take best practices whenever possible. Some of the focus, and I won't try to turn you into forensic geek here, but maintaining the proper chain of custody. You want to know about dates and times of activity, such as when was the device used, when was it inserted, the first time? What was inserted the last time? Were there any types of file transfers or cloud computing? What type of network access was going on? Maybe historically, maybe most recent, within the time of departure, things of that nature. What was their personal email usage within the corporate email system? In other words, were they emailing themselves, and if so, does it look like it may have been done on a regular basis where there could be an argument made that it was an ordinary course practice, or is it more like 3 days before they left, did they send themselves 50 confidential files? So those are all things that need to be considered. Some of the things that you look for, again, I'm not going to make you forensic geeks here, but some of the things you look for are link files and jump lists. And what those are in layman's terms is they're shortcuts that get created on Windows-based computers that show when files are opened. You also have shell bags that show when folders get access, things of that nature. So that would, for example, I like to give examples. If somebody were to insert a thumb drive and they were to copy, let's say, 10 files onto a thumb drive, and just to make sure that the copy was successful, they go back and they double-click on one of the files and they open it and verify it's there, there would be a shortcut or a link file or a jump list that I mentioned that was created to show that that file had been opened from that thumb drive. That's a forensic artifact that we can look for. Now, it won't necessarily tell you that there's an additional 9 files on the thumb drive, but it will tell you that one, the true way would be to look at the thumb drive there in that scenario. And I will caveat by saying every scenario could be different. Your mileage may vary, etc. I know I sound like an attorney. So here's kind of a storyline of putting something together where there was Dropbox usage, there was some folder access, there was a thumb drive being inserted, there were files copied to the USB, and then some files were opened from the USB. Activity timelines can help you tell a story, and that can be whether you're showing that something was taken. It can be helpful if you're trying to defend allegations of theft of trade secrets. You also want to look for evidence of tracks being covered up or forensic evidence being destroyed. This is from an actual case where the scenario here is that, let's suppose employee John Snow was employed from February 12 to 2013, and then when you start looking at the forensics, it looks like that there was an anti-forensics application that was installed and used, but it shows it was in 2009. So it raises red flags right off the bat. Wow, well, wait a minute, this is weird. If this computer was used in 2012 and issued in 2012, why are we seeing something from 2009? And in this particular case, what happened was the computer clock had been changed back in time, but the mistake that was made by the user was that they had connected a USB device, hard drive. They were reformatting it, wiping away evidence, and while they were doing that, they were browsing the Dennis Rodman's 2011 induction to NBA Hall of Fame, but it had a 2009 timestamp. For the basketball fans on the call today, you know that he wasn't inducted in 2009. He was inducted in 2011, so that could not have been possible that was one indicator, in addition to the other stuff as far as the clock being changed and things like that. So, Robert, it appears trade secrets have been taken, so what should we do next in the next 3 to 4 minutes tops?
Well, I think, when clients, come to me about what to do in these scenarios, a good investigation always needs to be done, because if you just run into court and you haven't dotted your I's and crossed your T's, then you're just asking for trouble. So you need to undertake a forensic investigation. You need to interview the key witnesses. You need to get a handle on whether the information that was taken is actually protectable. You need to do an assessment to see, what type of secrecy measures are in place to protect that information. Did the company employ non-disclosure agreements? How was their network system configured? What was their offboarding and onboarding type procedures? And really, you need to talk to the client about, what are their objectives. Is this a situation where it's a money damages case? Is it an injunctive relief case? Is it both? And how much time has gone by? Because you're going to be required to move fairly swiftly in order to go in and get an injunction. If you wait too long, the court will point that out and deny your relief. If you go in too quickly, the court may say there's nothing here. What's the beef? It hasn't percolated up enough yet. So that's the art of being a trade secret litigator, as far as knowing when and if you have enough. So I think our next slide deals with assembling the right team, and it varies upon jurisdiction as far as what is enough. But typically, there are jurisdictions where you could just have a verified complaint and it can be full of hearsay, and you can still at least get a TRO. But more and more, particularly I think in federal court across the board, the courts are requiring a level of detail and specificity, and they're looking at declarations or affidavits that have some meat. And so that's one of the important things you tell with your client, is that the injunctions are just not you press a button and you get an injunction because you believed you were wronged. You're really going to have to put forth a compelling story, and the business people are going to have to be involved in having been interviewed, in gathering the evidence, in sitting down and executing declarations and being deposed. And so oftentimes we see on the screen all these different individuals within a company will be involved in a trade secret case, and will in whole or part have to provide an affidavit or a declaration that'll be scrutinized by the court and subject them to discovery. So that's one of the things that you need to discuss with your client. Make sure that they're ready, and really give them the eye to eye, because they could give you the wink and the nod, but you really want them to understand that this is going to be an investment of their times and resources, and make sure that they're on board with that. There's different levels of escalation. Sometimes before you get to the lawsuit, you might just do a reminder of obligations letter or a cease and desist letter, along with a preservation demand, and that's that may undermine your ability later to get an injunctive relief, or it may not. Depending upon the judge, but that's a first step that you can consider taking, absent just immediately going to court. And I can't underscore enough the necessity of getting a computer forensic investigator involved in the case. Our federal judges, who have been schooled on iDiscovery principles and the Sedona conference and whatnot, they're becoming much more savvy as it relates to computer forensics and what can be shown and not shown. And if you go into court, looking for a very broad injunction, and you're not backing it with an affidavit or declaration from a computer forensic investigator, or you have some really vague and broad declaration from an internal IT person, the courts are looking for more. And that's why you need to be ahead of the game and make sure that you've got involved a computer forensic investigator, because oftentimes they can really tell you what's going on this activity, and it may look like you had a smoking gun, but then when we dig into the forensic reports, it may look more and more just like routine computer activity. And so the business people that were ready to jump off the ledge, you have to look them eye to eye and get them to realize that, we know that this may hurt your market share, but the guy just left. And his computer activities was just him doing a job. So those are the coming to truth moments that you need to have with your clients, and using a computer forensic investigator can really help.
Okay, so we're at the top of the hour, and we're going to turn it back over to the fine folks at MCC. We really appreciate everybody attending today, and you will get a copy of the slides, and we'll be happy to follow up with you as well. And please feel free, I will go ahead and move the slide to our contact information, and feel free to contact Robert for legal stuff and myself for questions are on the technical nature.
Absolutely, and all I would say is in the slides that we didn't get to, they may be worth your while as far as if you're making the assessment about being in state or federal court and whether you want to be bring a DTSA claim and some of the differences between the state trade secret claim and the federal trade secret claim and some of the requirements if you want to get an ex parte seizure order that you need to employ. So feel free to reach out to Jim or I if you have any questions in this area, and we really appreciate your attention, and we'd be happy to work with you in the future if you have any questions.
Well, great job, and thank you so much, Robert and Jim, for such a terrific presentation. Thank you to our audience for attending. Within the next few days, each of you will receive a link to the recorded event. If you'd like to refer back to it, you can also feel free to forward it on to colleagues. They'll just have to register, but they will be able to view it on demand. If you have any questions that were not answered, as Jim said, Jim and Robert will be happy to get back to you. Their contact information is with their bios. And we hope you found this webinar to be informative, and we look forward to having you join us again sometime soon. Thank you.